Greetings everyone. I Khushbu Chawla from Team Legal Vidya welcome you all to the 29th class of the 9-week certificate course on advanced legal drafting by Team Legal Vidya. Now, I would like to welcome our honorable speaker of this course, Ms. Shivani Gupta, to take the session forward. Welcome, ma'am.
Good evening, Legal Vidya. Good evening, Khushbu. And good evening, participants present over here. So today is here with the new class. And in the today's class, there is no SS schedule. There are two provisions of the Arbitration and the Conciliation Act. We will discuss in detail. I have already shared you the PDFs of both the topics that we will discuss today. If you all just received the PDF, downloaded them, then please let me know. Else I'm just sharing a screen and then we will start the session. Yes, you can download and get them printed and start preparing. In the today's section, we will discuss about the section number 34. Just wait for a second, I'm just sharing. And 36. Are you people are studying about the drafting topics that are being we are discussing daily in the class? Do you revise all those provisions? Very necessary for everyone. Just I hope the screen is visible to you all now. This is the same PDF I have shared to you also an hour ago. Today we will discuss about the provisions of section number 34. There are no as such draft, but these sections hold a kind of a very up kind of a relevancy when we discuss about the drafting and so on, because rather than the drafting we have to be acquainted with the provisions also, what's the provisions are saying, so about the act, what are the consequences of that provisions and so on. So today it's a new give a second. Yes, today it's a new section of the same section number 34, very important from the academic point of view also. First of all, just moving directly into the aspect and what is being written in the PDF, I am just discussing all those provisions in a very easy manner. In this same PDF, I am just running on the screen, is also having some of the case laws, so that are also important. When you write questions in the practical exam, you have to mention those case laws. Now it's a section number 34 that particularly talks about. Before just jumping into, just take prior history development and so on. So as we all know, till now under the Arbitration Act, 1990 was the year, but kindly we can could say that playing a very crucial role regarding significant changes are there in the arbitration legislation. The significant change, we can say that it's just like change in the time period for concluding arbitration proceedings. Means that in the 12 months only you have to conclude the arbitration proceedings. There is a provisions for the disqualification of the foreign arbitrators. So there were certain significant changes made. Now the primary reason was, prior to the arbitration legislation was highly problematic, we can say, and that also resulted in kinds of a delay, unnecessary delay, expenditures, and so on. So the 1996 the law was enacted, and then when the law was enacted, then for an arbitral verdict is enforcing that easy become easy, and then in that case now a problem arise. Issue is, if the claimant claim is unsuccessful, then what would happen? The arbitral award can be unpecuniary as a non-pecuniary, as we can say. For example, neither of the parties required to pay any kind of money to the another. So we will discuss about those provisions in the detail. Actually, according to the UNICITRAL model also, that model including section article number 34, UNICITRAL model, article number 34, and section number 30 of the Arbitration Act 1940. They are both are referenced, they both are kind being clubbed together, and that were just under the section number 34 they were referenced. So now when we talk about setting aside of arbitral award, section number 34 of the same act, that is the Arbitration and the Conciliation Act 1996, clearly specifying certain grounds that are for challenging the arbitral award that are being rendered under section number 31 that we already know. Actually, the PDF that I have shared is for the academic purpose, and what I am reciting from here is just the explanation of the PDF that are being made. So these are the basics you must be acquainted with. And there is no as such rule of sharing the screen and all. That's why I put on the PDF of the same. Now there was a one case law. So if anyone want to note down the case law, very important, then they can note down. It's a case law of Municipal Corporation of Greater Mumbai versus the Press Products India Limited, in the 2003. I'm repeating the case law Municipal Corporation of Greater Mumbai versus Pestless Products India in the 2003. The court particularly held that the new act that was the 1996, which was enacted with the explicit parliamentary goal of limiting all kinds of judicial participation, and by which the scope of the prospective challenge to an award is greatly reduced under section number 34. Now, first of all, the first thing that comes into the mind, we discuss about section number 34. It is, what is arbitral award? So, arbitral award is a decision, we can in general say, made by the arbitration tribunal in an arbitration proceedings that is believed to be equivalent to the court of law's judgment, we can say, or the uh, concerning of certain exceptions also. The award may also provide the parties with a certain number of remedies, including money, consent, injunctions, temporary injunctions, permanent injunctions, and a number of other remedies. And depending upon the nature, also, the award can be, for example, first is interim, followed by partial or the final. And now, section number 31 also of the Arbitration and the Conciliation Act also state that the arbitral awards must also include the reasons that for the decision, unless the parties why the parties will agree for that reason should be given, and the ruling is arbitral award the green condition under section number 30. Now there are certain conditions also in which an arbitral award can be set aside. So it's just like, for example, I mentioned are the amendments to the section number 34 applicable prospectively and the retrospectively. So when we discuss about this thing, that the conditions in which arbitral award can be set aside, then we will come to know about the amendments also. Section number 34, actually there was no need to mention whole of the section on the screen, that you can also cover from the bare. Actually there is a need for the explanation. That's why I didn't put section on the screen. Now, there are certain grounds, and those grounds are very important, just on the behalf of which court can set aside the arbitral awards. And those grounds can be the incapacity of the parties, agreement not valid, other parties are not notified, subject matter beyond the arbitration clause, and so on. Composition of arbitral tribunal not as per the contract. So these are the conditions. Now, when we discuss about the condition, it is just like a incapacity to the of the parties. So, what happened if there is any of the parties under the age of a majority or is a minor, they are not obligated to follow any of the agreement in the place. As a result, what happened? The agreement become void, and any award made in such case may be revoked by the court. We will discuss it with the example. For example, a woman who is suffering from or infected with schizophrenia, then a psychotic disorder, can through their and can be through their representative apply an award to set aside. The incompetent person can, however, apply to the court for the appointment of a guardian for the arbitral proceedings under the section number 9 of the Arbitration Act. And after that, the ground for the incapacity of the party will cease to exist. Now, another thing is agreement is not valid. In order for a contract to be enforceable, all of its essential elements must be met. If the contract is illegal, the arbitration agreement will be declared void as well as the arbitral award can be revoked. There is a one case law also for the same, that is the Adarsh Kumar Kheda versus Keval Krishna Khera. I think you might, if you studied about the arbitration, you might have discussed about it. The facts and the case AIR was 2007, and the facts were like arbitral award was set aside since it was made without giving a parties a chance to be heard. It's deemed to be void, and moreover, the both the parties wanted it overturned. So this was also a ground that the agreement is not valid at all. Okay, anyone of you would like to tell me any of the ground? For example, other parties are not notified. So it can also be the ground or not. Uh, I'm asking the grounds for the conditions in which the arbitral award can be set aside. Actually, it shouldn't be a monologue session that I am just speaking unstoppable here from here, and you are not just saying anything, any response. Please put in the chat box. Do you really think so that other parties were not notified is the ground for the same? Either put yes or no or something, any of the ground. Yuvraj saying yes. Yes, Yuvraj, we will support your thing with a case law first. The case law was, I think, Ahluwalia contract case. Everyone must remember that case. Ahluwalia contract case, that is of 2016. AKM Enterprises versus Private Limited versus Ahluwalia contract case. In the case, what happened? It was an arbitral award was set aside on the basis of the fact that the arbitrator would not arbitrate upon a counter case of the applicant on the merits, and on the ground that the no notification had been preceding the subject assertion, and hence the council didn't have barred to engage something very similar, which is in opposition to settled place of the regulation that for the reason for the counter case to limit assortment of the processor, and also that in such case the court would have the purview to arbitrate upon even them without any early notification. There is another ground also, that is the subject matter beyond the arbitration clause. In that case, we discuss about the India Yamaha Motor Private Limited versus the Vyashi Jambal case, and it's a very recent case. And this case was also cited in 2019. The arbitral awards were set aside because it was issued in the violation of contract provisions without taking into account relevant evidences on the life and based on assumption. There is another case law also. I didn't remember the whole name. That is the Hindustan Petroleum Corporation case. Didn't remember the whole name right now. And case was of either 2018 or 2019. If I got the case name, I will share it to you. But the case name was the Hindustan Petroleum Corporation Limited case. If anyone found the case law, then please put in the chat box. Meanwhile, and this was also held that the arbitrator should have limited themselves, I mean, to himself or herself, to the problems and agreement that has been present for the arbitration. There is another ground also, that is a composition of arbitral tribunal as per not the contract. If arbitrator is not appointed in the accordance with the provisions of the agreement by the parties, or if any other administrative aspect of the agreement that was determined earlier by the parties has not been fully implemented, the aggrieved party may seek to have the award set aside. There is a very important case law that is also of year 2018 or 19 by Bharat Sanchar Nigam Limited versus, that is the Maharashtra knowledge case. Knowledge. Didn't remember the whole case name, but that is the Bharat Sanchar Nigam Limited case. The award was just partially set aside because arbitrator here more failed to examine important information while making decisions on the account of which the arbitral tribunal was formed, and that also resulted in the breach of terms of the contract. These are the certain grounds. Other than that, there are a few follow fellow other grounds also and the other grounds can be just not adhere to the public policy. So this can be a ground also. Who will just explain me? Not adhering to the public policy in our country, is this a ground to set aside? Yes, anyone? And if anyone saying yes, then please support your yes or no with any of the case law or the statement. No one is saying yes or no. Are you participants getting what I am trying to say today? There is no draft to share. I know theory is little bit boring. I know theory is little bit drowning. It's just like we fall asleep, but we have to study the theory also, because when we are once good at a concept, we are our aspects conceptual clarity is there, then only we can. Uh, I believe since it's conflicting with the societal norms, absolutely. Anamika, yes, Tejashri, just raise your hand. Please just unmute yourself. If you have any query, or put in the chat box. Yes, Anamika, totally agreed, and would like to support your statement with the case law, that is the Steel Authority of India versus the Primetals Technologies, and it's a case of a 2020 only, where the court can set aside, because partially, but partially can set aside as being against the public policy, because an extraordinary high interest rate of 14% per annum was given without any justifications in comparison to the current interest rate. And there are also things like high interest rate look to be the punitive in character, given in the circumstances. As the result, this interest rate become 10%. So that is a very indigenous rate interest. That's why. And now, and these are the conditions in which the arbitral awards can be set aside. But I think everyone would be like, okay, ma'am, are there certain conditions in which the arbitral award can't be set aside? How many of things so that, okay, there are certain conditions the arbitral award can't be set aside? There is a provision for the section number 34, subsection number 3, that the arbitrate under the Arbitration and the Conciliation Act, that the limitations in which the arbitral award can't be set aside. So there are certain conditions for that also. These certain are the case laws that I have mentioned. You can go through the PDF. Might be helpful for you all for the academics also. Yes. So the grounds we are discussing now about the grounds. Grounds, first of all, is just like application filed after the 3 months when the award was received, because the no code will consider the application to set aside an award if it is filed the 3 months. 2 3 months have passed since the application received the arbitral, according to section number 34, subsection number 3. The caveat is just that the further the that if the court is convinced. Yes, Anamika, we are discussing those grounds only, conditions only. And the first condition I have told you, that the application to set aside the award is being filed after the 3 months the award was received. So this is the first ground under the section number 34, subsection number 3. Because not no court will consider that the application to set the aside the award to be filled to be filed after the 3 months have been passed, because there is a provision for the same. But the caveat is also there. Caveat says so that if the court is convinced once that applicant was prevented from making any kind of application within the necessary time by sufficient reasons, then the court may hear the application for additional 30 days. But beyond that limit, not provided at all. Next ground, that is the erroneous application, misappropriation, or misappreciation of the evidences. there is a case law named Haryana Urban Development Authority versus the versus it's a Mehta Construction Company 2020. So again, a case where the Supreme Court clearly held that while questioning sets aside the judgments of the Punjab and Haryana court, then the arbitral award can't be set aside because of the simple erroneous applications of law. Now there is also a public policy fact also, rationals behind the awards also. Rationals are is that the award must be reasoned award, but unless the parties stated in this agreement that there was no need for the reason or if an award made on agreed conditions under the section. Now there are certain limitations also. Limitations we can say that first of all, the limitations is just like if the applicant can demonstrate to the court or convince the court that there was a sufficient cause, sufficient reasons that prevented him from filing the application, 3 month time period must be extended to another 30 days. And after the 3 months, the section itself also says as the thumb for constructing time to be regarded as the calendar month rather than the 90 days span. So these are the certain things about that. Now, a thing come to in the mind is about the reliability of the arbitral award. So yes, for first thing, na, you have to always keep in mind that the arbitral award is comparable to the court verdict. Why? Because it is as binding on the parties and crucial in that it aids in the resolution of the disputes among them. Important factor in deciding challenge arbitration judgment is whether the arbitration decision is binding or not. So for that, we can refer one case also, Rajasthan State Mines and Minerals Limited versus the Eastern Engineering Services. So these are the certain case laws for the same. Now there is a one subsection 4 also of the section number 34, that is the parties must invoke the section number 34 subsection number 4 of the arbitration act. The court can't exercise its power under article number 30 section number 34 subsection number 4 of the arbitration act on its own. A party to the arbitration proceedings must submit sorry, written application under section number 34. So now on the conclusion mark we can say one thing, and everyone is just like, because we have to understand that the primary reason for the parties to select the arbitration over the litigation is to resolve their disputes and obligations quickly through an arbitral. Most arbitral rules only specify the award is binding on the parties, but the current arbitration rules and the regulations also just like putting a clear or legal framework that are addressing the conclusive effects of an arbitral award. So, that's all with the section number 34. Now we will jump into the another section. The section number 34, any of the participants here, 18 participants are there, excluding me. 19 people are there. So please ask any kind of a question for the same section as we will jump into the next section. If everything is clear to you all, then please give us a thumbs up. I will share the another section. Okay, good going. And please just revise. It's my kind request to you. After the class, what is being taught, please do revise. Just wait for a second, I'm sharing. Now it's the section number 36. Section number 36 of the arbitration award. Yes, anyone would like to explain what is section number 36 is about? Anyone would like to make an attempt? It's for the execution of the award. Simple term. The word enforcement that is being defined under section number 36 could be like An application is made to set aside the arbitral award under section number 34, as discussed earlier, will get expired. It shall be subjected to the subsection number 2, that in the 30 days only you have to file the application, and the award shall be further enforced in the compliance with the CPC. So these are the provisions for the same. Another thing is section number 34 also talks about setting aside the arbitral award that is being filed in the court. And if filed, then it shall not make the award enforceable until and unless the court also gives direction in form of a stay on the arbitral award. There are certain satisfactions also for the court that prima facie, that is, are stating about the basis of the award concerning the contract or the agreement making of the award. There is a some case laws also. On the in the section I have screen, I have put forth the section. You can directly read the section. Two case laws are there, important case law. Malwa Strip Private Limited versus Jyoti Limited. Another is National Aluminium Company Limited versus Steel Fabricants. So now there is a retrospective application also. Retrospective application, we can specify like consent concept of the enforcement and the execution must be dealt with simultaneously, because the enforcement is sent out substantively and procedurally with the execution. And the section number 36 also refers to the execution of award, and the decree of execution is just a part of the procedure, and it's just not like deriving any of the substantive right that is being vested in the award. There are certain features also, features for the section number 36, we can say it's just like for example, automatic is taken from the arbitration act, but only the filing a challenge in the compliance with 34 section number 34 will not affect the enforceability. And there are certain pronouncement also, judicial pronouncement, that is the BCCI versus Kochi case is there. Siliguri Jalpaiguri Development Authority versus West Bengal Court. Now, very important question to answer right now is, you must be thinking about how do you execute an arbitration award? Yes, anyone please can explain? I think till now the concept is clear to you all. How can you execute an arbitration award? Anyone would like to take a chance to answer this question? No one, no worries. I am just telling you. So, first of all, it's just like once you receive it, there are certain time periods. Yes, there are certain time periods. And it's also, you can tell, like, upon receiving the stage of finality. And if there is no such stay on the execution that is being the court granted, then that is also does the award holder knock on the doors of the appropriate as an executing court to executing the award as if it was a decree of the court. And the certain time period you are talking about, it's just already mentioned under the subsection number 3. It's about the 90 days, that the 90 days time period is there, Anamika, for the challenging the award. Means that 3 months limitation period is intended, and that intended period is just to ensure the finality of the arbitration award, and there is no as such duly delayed. So that's all about the section number 34 and the 36 of the Arbitration and the Conciliation Act. Yes, Anamika, good going. Yes, the 90 days is there. And if the person is just convinced the court, more than the 30 days will be given, because there must be the reasonable grounds that the person was not allowed to, and so on. I think everyone must be acquainted with both of the section provisions. Okay, Nishtha, okay, Anamika. And I know it's very hard just to get acquainted with the concept in the online class. Please just go through the PDFs of what I am sharing. That would be easy for you all just to go through the concept, and just please keep the PDFs with yourself, would be very helpful for your academics and in the future litigation, and if you are going in the research also for the teaching also, then also might be very helpful. Okay. Yes, that's all for the today's both topics as per the schedule. I think that's all. And काफी ज्यादा बोल चुकी हूँ मैं, गले की हालत अब बिल्कुल खराब हो रही है, तो I would like to have the session. And you also please take care of your health, because health is wealth. And nowadays we are just losing the health because the weather conditions are at the poorest. Even we can't breathe properly. It's whole of everywhere. It's just the weather conditions are the poorest. And my throat has just gone very sensitive. Yes, Anamika, I am just taking caring of myself, but I don't know, because I have to take 4 to 5 classes daily, and that's the thing. Now we are in a mood court competition, so that there are also lots of talking discussions there. That's why. Dear participants, you also please study hard, read as much as you can. Please read. Read. Just spend your weekends on reading only. No scrolling, no Insta, no video, nothing. Just reading, BRX, books, everything. Stay safe, stay healthy, take care of your health. Like me. If Legal Vidya is there, then please wrap the session. Unless, thank you everyone. Please take care.
Sure, ma'am. Thank you so much for such an engrossing session. Also, I would like to thank everyone for joining the session, and also take care, ma'am.
Thank you, Khushbu. So kind of you. Take care, everyone. Take care, Khushbu.
Thank
Stay
you.
safe. Thank you.